One of the things that was discussed earlier, Bill, before you got here, was the, I think Robert Purse made the point about feeling that the file is the client's, and that's been some issue with some of the trial lawyers, is turning over the file to the appellate division, for instance, when they're ready to take an appeal. You know, our position would be that the file is the client's, and we should get it, you know, for folks to be able to review. But you know, I know the DeKalb County Public Defender's Office may take a slightly different view of that, but we believe that the file is the client's, and we do everything to try to make sure that they get that amongst all the rest of the information in order to do an effective appeal.
State Bar agrees with you, but most trial lawyers like their bar license better than they like the file.
How routine is it to hire an expert lawyer to establish the objective unreasonableness of trial counsel's performance for the motion for new trial?
That's sort of frowned on.
Yeah.
Judges are not going to provide that.
Proliferate.
I mean, I've certainly had hearings where an attorney is brought in to give an opinion, an expert opinion as to what's reasonable, but that's just that attorney's opinion.
The judge was there, he knows better.
The judge, it's the judge evaluating your claim.
Yeah, and I guess the judge has an opinion that they're a legal expert as much as anyone. So
I think that's the bottom line.
Any other questions about ineffective assistance? Again, I think everyone will be here for a little while, so please feel free to pull them aside and ask questions later on as you go along. If you take cases and you come up to issues. We're going to move directly into our next panel, which deals substantively with the brief. We've looked at spotting issues, after you've digested the case, after you've vetted the issues, after you've talked to other attorneys, we have talked to some individuals, some of these on the panel at the appellate division. Now it's time to craft your brief, which is going to deal with looking at how you develop the theory of your case that you're going to put into writing. Oh, I'm sorry. Okay, and for these individuals here, we're going to have a round of applause. This next panel is going to include, once again, Chris McFadden and Gerard Clamrock from DeKalb, CPD office there. And then once we finish this section, which will end at 4, then we will take a 5-minute break and go into ethical considerations. So if you need a bathroom break or something like that, just get up, run out, and come back. And we're going to try to make sure we stay as close to being on schedule as we are not right now, and then get you out of here at the end of the day.
Are no rules. This is sort of more fuzzy stuff. But that said, make sure you follow the rules. I'm not going to talk about them a lot, but there are rules out there and they need to be followed. So just read the rules of the Court of Appeals. There aren't that many. There's only 3 or 4 rules that have to do with briefs. They'll even tell you things like font and type size, and they mention now times. They used to mention courier. You know, use the one that they mentioned. That probably means they like it. Now, what I meant by no rules is this is kind of strategy stuff. It's not like hard lawyering. The hard lawyering is the research you do to get to write the brief, but brief writing is maybe more of an art. And I guess when I thought about this today, and we'll get to the panel in a minute, but I thought about a legal writing seminar I went to a while back, and the one thing I really took from that seminar, sort of in my own words, is try to avoid cognitive dissonance. Even not really my words, I guess some psychiatrist words. But, you know, in concrete terms, they put like, look, I'm going to talk about 3 things, 1, 2, and 3. Okay, here we go, A. And the reader's going, A? I thought you said 1. But I try to make that a little more practical. Like when I proofread a brief, I want to make it so that I read it or someone else proofreads it, they don't have the slightest question at any point. You don't want to be reading along and have a question, and don't worry, that's going to be answered in the next paragraph, because then the reader's thinking about that. Let's see. I guess I brought some examples of some things I like to do, and I included, there should be in the CD, should be like 2, maybe 3 sample briefs that these are from, so you don't necessarily have to do it. But I'm a big believer in making it easy for the reader. Yes, you're writing to lawyers, you're writing to judges, they've been to law school, but you want to, or I believe in bringing it down so that they can just read it and get it and not have to really think. And there's something, I get this, I got this from Justice Namias, but I've sort of been doing this all along, is he pointed out that they have such a workload that they do their work at home sometimes. So he might be sitting on your couch at 10 o'clock at night reading your brief, and if you're citing to OCGA XYZ, he has no idea what that says, and he doesn't have a book right there, and he could, I guess, get up and go to his computer and try to look it up. But why not make it easy for him? If it's not that big a deal, drop a footnote and just say what it is. I am a huge believer in quotes. I use quotes all the time. The reason I use quotes is because it tells the reader that's exactly what happened. They don't have to think, is Kleinrock paraphrasing the case and doing it wrong? Is he... And that goes with the law and the facts. And I'll show you from some things, like here's a standard of review. Let me see if this... There's my standard of review. You might see some people give the standard of review in their own words. You can see there's not a single word line in there. And then you go on to, maybe another issue. Again, it's quotes. And standards of review is stuff that the courts pretty much know anyway. It's not like I'm convincing them that much. But still, I love quotes. I strongly encourage use of quotes whenever you can. From the facts, anytime you're talking about the facts of the case. Here, for example, the state's star witness, this just pops up, Miss Boyd admitted, quote, "I'm a crack addict." That's not me saying that. She said it. Doesn't that sound a lot stronger than me saying, hey, the state star witness was a crack addict? So I believe strongly in using quotes because, it tells the reader this is true. This is not someone's opinion. This is actual truth. Along the lines of making it easy for the reader, I'm a big believer in headers. And this is, again, you've got these briefs in your summaries, but this is just a table of contents. My table of contents just cuts straight from the headers. So you can see there's headers, there's subheaders, there's sub-subheaders. It all goes along so that when you're reading the brief, you can read the header and say, okay, this is what we're going to be talking about. And the more, otherwise you just got like a string of words that goes on forever, and it's hard to break it out. And I think it comes off as much more compelling for the reader if they understand what you're talking about, and they can, it's sort of a roadmap of where it all goes. And just so you can see, now this is, Mr. McFadden was talking about, I think this would be a SURF case in the realm of number of issues raised. I had 13 issues on motion for new trial. I mean, this was I'll give Mr. McFadden, this was an unusual case, and I had a real hard time calling them because I thought they were all good issues. But this is the continuation, just so you know, of that table of contents and all the issues in the case. I mean, it just goes on and on and on. And just this actually brings me, this is probably not a good example. When I was saying there are no rules, I had an intern just probably a month ago proofreading a brief. Anyone who wants to proofread a brief, I'll have to proofread a brief, and it helps, even if it's an intern, even non-lawyer, it doesn't really matter. But he was reading something and he said, there's not enough sentences in this paragraph. This is maybe a 2-sentence paragraph or something. there's no rules to writing, it's whatever sells. I had a case where I let, the state's witness lied to the police, and I made the strategic decision to start my facts with the lie. So I had 2 pages of his lie in great detail about how much detail he went into with his lie and how he was challenged and said, no, it's absolutely true. And then I had a 3 or 4 sentence paragraph, but this was all lies. And that sells, because that's all there is to that paragraph, and it kind of screams out at you, if you bury it. So one of the non-rules I want to talk about, I'm sorry, this is kind of more like a speech than a pamphlet, but we're going to pass it on. Headers, I think when I first started doing this, there was this sort of natural inclination. You want to try to write this run-on sentence for a header. You want to get it all. There's no reason you can't have a period. It makes it easier to read. A header doesn't have to be a sentence. It can be whatever you want. Let's see, there's just a couple more things that I am a big believer in. And this one I actually learned from DAs, just from doing this so much. And I noticed the DAs always start their brief, at least in DeKalb County, and you guys can tell me if they do this statewide, but they always start their brief with an introductory paragraph that says, and I'll paraphrase heavily, defendant is a piece of... And it's not, I don't think that's as effective as it could be, but I realized, they're basically saying, and they say why, some cold-blooded killing and blood everywhere, and now he's trying to get out of it. That's basically their point. And after a while, I started realizing, they're summarizing the case, although they're not really. They're just trying to act on emotion. And then I started realizing, it's effective to sort of summarize your case up front. So now I'm a big believer in introductory paragraphs, and you can see this is a statement of the facts. I mean, the only thing that comes first is a bunch of dry, such and such was filed, such and such. And then this is the first time you get into the case. And it starts, statement of facts is normally a whole bunch of, citations and quotes. But I wanted to lead with what I thought sold this case. 2 hung juries. I mean, that's huge for the harmless error analysis. The main witness is a crack addict and was gotten all kinds of trouble from the judge, and the judge threatened to lock her up, and she was refusing to answer questions, and the case turns on her credibility. Now the court is starting to read this brief. Then they start getting into, okay, now let's hit us with the old chronological what happened. If you want to do it in chronological order, again, no rules. But so I strongly encourage you, probably for any kind of writing, but for brief writing, I think it's important to start the case with a quick, punchy summary that frames the case the way you want it framed. And this is why I come back to, I'm not sure the DAs do such a good job of it, because all they ever say, it's consistent, is, this client deserves to be locked under the jail. But they don't really say why the appeal should be affirmed, which is what I think they should be saying if they're doing a good job. This says why this one should be reversed. I mean, it really doesn't. If you read that, you don't necessarily know what I'm going to raise, but once you start reading it, you've got in the frame of your mind, now this was a very questionable case. Let's see. One thing I think a lot of people don't do that I've come to be a strong believer in is real conclusions. Just 99% of briefs you'll get to the conclusion, and it says for the aforementioned reasons, defendant asks, the case to be reversed. Well, summarize it. And this is strange for me. I don't know why it always seems to happen to me. And actually, I do have a hypothesis, but I always seem to write better in the conclusion. It's more punchy, it's more sort of energetic and emotional. And it's probably because when you're writing the other thing, you're bogged down in where's the case that says this, and when the conclusion is sort of more free, and it just comes across very convincing. And then you can take some of that and put it back in the main brief. But to me, it's very compelling to have a real conclusion, so that the last thing the court reads is a very direct summary of what's in this case and what turns it around. And I guess one thing I did in this case that I don't necessarily do in all cases, but I think it's good if you can, is to have a consistent theme. And this was maybe almost a rare case where the appellate themes all worked together and they all turned around a gun in a holster. You know, there's all kinds of, there's ineffectiveness and motion to suppress and all kinds of stuff that all went to that. So this whole conclusion is all about the gun and the holster and everything. Eventually, that did get Mr. Cobb's case reversed. And let me just, this may be an aside to brief writing, but let me just say, we've been talking a lot about ineffectiveness today, and I think I've tried to make the point, it doesn't necessarily mean that the lawyers are bad lawyers. Mr. Cobb's case, and you wouldn't really know this from the Supreme Court opinion, but it gets reversed on a hearsay objection. And you wouldn't know this, but it's a hearsay objection that the lawyers made. They just made it to the second time the question was asked and not the first. So you've really got to be on the lookout because the state's number one issue, the thing they love, if you're a DA, the thing you love is to argue waiver. And our answer is ineffectiveness. So even if you think you got a good, clean issue, be wary. Look if there's any way they can twist it and call it waiver, and then you've got to twist it back and call it ineffectiveness. All right, Mr. McFadden.
I'm standing there. Let me add just a few additional thoughts. One about the perspective of the courts. One of the realities of the court is that judges have less time to examine cases than the lawyers have to present considerably less time. And so it is vitally important that in drafting a brief you think about the caseload, the time pressure that the judges and the judges' staff are operating under. That means winnowing arguments. That means erring the side of brevity. That means keeping your fact statements lean. Those are generalities. A little bit more specific. I agree that introductory paragraphs are very, very useful. I always use them. The Court of Appeals requires Part 1, 2, and 3. I do an introductory paragraph before Part 1. The purpose of the introductory paragraph is twofold. It is to be persuasive. One suggestion that has been made to me is that you ought to write a brief in such a way that if the court stops reading at any point and just accepts what you've said, you'll be entitled to a reversal, or you're entitled to prevail. So I want in my introduction to summarize to assert briefly what the key argument or arguments are, and enough about the facts of the case to minimally understand it. And what that does is as you start going into the facts, which may move into a chronological description of things, answering the question that is at the back of the court's mind as they're going through this, which is, why do I have to learn this? And do I really have to learn this? A classic example is overloading the court with a bunch of dates that don't really mean anything. They're done really just out of a sense that of the need for completeness. If they don't need a date, if a date isn't necessary to put things into context, then leave it out. The introduction can serve as a roadmap to what the issues are in the case, and again, as I said, follow the roadmap. I also agree that the quotes are extremely useful if they add to the writer's credibility. And one caveat, a suggestion that I have seen is that a lot of readers are put off a little bit by block quotes. I still think that they're useful and important, notwithstanding that I've heard that. But the answer I've said to it is, before you put a block quote, almost always you want to put a sentence saying what the block quote says. And when I have a volume block quote, I like to highlight a line or two that's the key information so that the eye can go to that and not feel the need necessarily to follow all the way through. And of course, you've got a block quote under standard review item 1, that's kind of blue 2. Another suggestion about lean writing is avoidance of adjectives and adverbs. And generally avoid strident writing. What is effective in an appellate argument is not fireworks, but just the facts. That if you have a witness that you're trying to demonstrate ought to have been better impeached, or that witness' testimony is rather feeble, the fact that the witness says, "I'm a crack addict," it really doesn't need a whole lot of addition from the lawyer pointing out that this is a bad thing. You want to steal the other side's thunder. I think I'm telling you things that all of you who've done advocacy of any kind know very well. You don't want to leave anything unsaid or unaddressed in your brief, so that when the other side can introduce it with great drama and suggest that you have been disingenuous about doing it. Because in a criminal case, usually there are some very unpleasant facts. The DA will want to dwell upon them in sort of a prurient way. We just need to lay them out and acknowledge them. There is an awful lot of good stuff written about legal writing. Judge Gottwald's 20 pages in 20 minutes is required writing. There's a lot. One suggestion that is made by Professor Garner, who is now the editor of Black's Law Dictionary, and has written a book with Justice Scalia, many other things about writing, and does very expensive, wonderful writing seminars, suggests a little device that I've put on the table there. And this is a means of thinking about a case where it's fairly complicated and you're struggling with how to organize it. And you just make notes there about the issues. A point here, a point there. If you've got a point that's a sub-point, put it over there, some sub-point over there. The idea is just laying out the various ideas. So this might be witness lied, harmful error, failure to object, ineffective assistance. Connect them up, and you can, looking at that is a way of just thinking about how to organize the ideas. This is something you might want to do in pencil. It is a useful exercise in organizing a complicated bit of writing. Finally, I want to just recur to Aristotle. The classic description of persuasive writing is logos, pathos, and ethos. And I think that is something essential to keep in mind. Logos is the logical argument, and we have 3 years of law school under our belts to tell us all about that. Pathos is the emotional impact of the story, and that is the necessity to tie the logical arguments into a narrative. It's necessary to tie it into a narrative simply because our minds, particularly the things that we're talking about, organize things in terms of stories. It's possible because we are engaged in a process in which it boils down ultimately to the pursuit of justice. So we want to make an argument that relates to the pursuit of justice. As I said earlier, generally it's either that this truth-seeking function has been meaningfully undermined, or that our fundamental liberties are eroded by this sort of practice. And finally, that's come down to ethos, and that boils down to canon. You want to make sure that that the other side is not able, in responding to you, to show that you have in any way misrepresented the facts of the law. It is supported by rigorous citations to the record and to the applicable law, accurate quotations, accurate citations, precise quotations, complete candor to the court. And, think a little bit about politics. As you read about, if you are at all engaged in politics, you are aware of some commentators that you think credible, and you are aware of some commentators that you think not credible, that you think utterly dishonest. And if there's a commentator who you think utterly dishonest, who is trying to tell you something where they are right and are dead on, they will be unsuccessful in doing it, particularly if there's any complexity to the idea at all, because you will not trust the word they say, and you will find it difficult to follow them. So a lawyer who squanders credibility, squanders candor, squanders ethos of the court, gravely squanders their ability to persuade society.
Chris, phrase it out. In the materials, is there a sample brief? We were talking about whether, has anybody laid out just the correction of errors and that kind of stuff?
I think I put 3 briefs, at least 1 court of appeals and 1 Supreme Court brief in sample briefs of mine in the materials. And I think maybe there may be some others in there too.
And I'd like to just mention a little bit about the structure of it.
On the discs.
I think the way to write an appellate brief in some respects, in terms of the structure of it, is pretty much the same way as that you would write a trial brief. You write the law, you write the facts, in whatever order you normally do that. If you're doing that in a rigorous manner, keeping in mind that your audience does not have any memory of prior proceedings and has to look at the whole record, and is subject to these standards of review, if you're writing those things in mind, the additional requirements the appellate courts have will follow pretty readily. The rules of the Court of Appeals require that the case be divided up into 3 sections: the facts, the enumeration of errors in the law, and there's also a requirement for establishing preservation of error in jurisdiction and standard of review. But it's, other than the need to enumerate errors and follow record, it's pretty similar to other brief writings. The same thing basically applies in the Supreme Court. The Supreme Court is less demanding than the Court of Appeals is in terms of the format of its brief. And really the requirements of the Supreme Court as the format are just a suggestion that are a footnote to its rules, saying these are things that you ought to cover.
You can be creative in, you can be creative within the structure of the briefs, the way the Supreme Court and the Court of Appeals wanted. You can still be creative. One of my favorite briefs that I wrote, it was a very complex case, a lot of facts, a lot of issues, and I wanted to make sure the Supreme Court had a grasp, an overall view of the thing, so that then later when we start talking about individual issues, they could go back and see where it fit in. And it occurred to me that I had to do something a little bit different than just a recitation of the facts. And I started out with background, and it was like one or two paragraphs of background. Here's what this case is all about. And then it was like a page and a half of summary. And I'm trying to think of that. I can't remember what I labeled the third part. What's a synonym for summary? Outline? But it built on itself so that you go back. Oh yeah, when the justices are reading the brief and they're deep into your 15th enumeration, and how does this fit in? They can go back. They remember there's background that'll show me where in the timeline it fits, or then a little bit more detail in the summary, and then whatever the third part was. You don't have a good synonym for that, though. So you can be creative, think about, how you would want to read it, how you would want to be informed about the case. And then within the structure, you can be creative.
Preamble.
Freedom?
Preamble.
Preamble. Was that right? Preface.
Yeah, I just had a few bits and pieces I wanted to add. I actually couldn't resist a war story that kind of illustrated something that Gerard and Chris have both said, and they're talking about the obligation of candor. And, I think you call it pulling the teeth, where you sort of want to set the bad parts of your record out in the best light before the other side rams them down your feet. I had a case many years ago. Matter of fact, Carl Greenberg was on the other side of that, although he had by that time moved from the public defender's office over in Fulton. But it was a terrible murder case. And somebody earlier made was talking about the remark about killing somebody in cold blood in front of people who knew him since he was 5 years old. And that was this case. Matter of fact, this guy had murdered a policeman in high noon in this housing area where everybody knew him and few people liked him. The identification was just absolutely cold. And on the merits of the case, there wasn't, the defense, I think, was playing for error or playing for attrition. And there were issues that related to the guilt phase, but the case was essentially tried, as far as the defense was concerned, for the sentence. But in any event, writing the statement of the case was sort of a challenge because you didn't exactly want to. I had to deal with the fact that my client shot this policeman in the back in cold blood in broad daylight in front of 40 witnesses and knew him. I couldn't. I had to deal with that in some fashion. What I ended up doing, actually, though, was writing the statement of the facts from the standpoint of the sentence. And so I wrote them from what the defense had presented about this poor kid being born, into this terrible household and, neglected as a child. And they had, childhood teachers that had testified in mitigation and that kind of thing. And I essentially brought the case up that way to that, by his sordid childhood and growth to that incident, in this public area where he committed the homicide. And it was an interesting way kind of dealing with bad facts. I didn't exactly ignore them, but we weren't telling that's not the story we were telling. That was undoubtedly the story the prosecution would like to tell. But as I said, the defense was not concerned with really with guilt or innocence. We were concerned with the sentence. And actually that probably illustrates something else, that when you're doing just the introductory parts, your statement of the facts and that kind of thing, you want to write them with reference to what your issue is going to be. As Chris had mentioned earlier, the court does not need extraneous facts. The court really depends on you to eliminate the stuff they do not need to know. And the problem is that if you include some of that, and I've proofread a lot of briefs where they spend a couple of paragraphs about something that makes no difference. And if you are reading that brief, you feel kind of misled a little bit because you sat there and you're thinking, where is this going to go? And then you get to the end of the brief and you realize it never went anywhere. It was just something else, something that was erroneously thrown in there to sort of, just simply to get in the way of the point. And that's really a part of proofreading, which is another thing I wanted to talk about. I think Gerard mentioned the value of having somebody read the thing, and that's I can't emphasize that enough. It's good if it's another lawyer. It's good if it's another lawyer who's somewhat familiar with the case. But anybody, your wife can do it, your husband can do it, your kids can do it. But if you get a neutral reader in, that person can identify the areas where there's some unnecessary ambiguity. Who the pronoun he relates to, for example, somewhere in things like that, which as the writer, you would not catch. You've got all this stuff in your head. You don't necessarily know where you might have misled the reader or given the reader something to stumble on. You don't really want him to stumble on anything. As a matter of fact, what you want is a brief that marches, to the extent it can, in a straight line, and goes and grabs the reader and takes him step by step by step, irresistibly, to the conclusion that you want that reader to draw. In terms of proofreading, that there, you always look for redundancies, and redundancies are built in. They happen in any kind of writing, but in terms of a brief, they're an important signal. Usually, they actually mark when somebody stopped for the night and came back the next day to get writing, or broke for lunch, because you're coming back in and you're starting where you left off, and you need to kind of get up, have steam again and go, and that's a spot where redundancy can occur. But quite often what they illustrate is a place where your argument, instead of marching straight, has for some reason or another felt compelled to circle right around and pick up again. And so there's sort of a loop in the path, and you want to, as I said, it's a signal. Look at why that loop is there and see if you can eliminate it, because you do want to eliminate it. Gerard talked about being a great believer in this and that and the other. I guess I bring to the table my great belief in footnotes. I probably like them to a fault, but essentially they just visually and in every other fashion, they represent sort of parenthetical material that we all probably would like the court to know, but we know they don't need to know it. It's just something maybe interesting or something that throws light. And a footnote visually subordinated to the text is a perfect illustration of that. You're saying, just simply by the placement of it, this really isn't important, this is interesting. And you kept it out of the narrative of either your statement of the facts and the narrative argument that you're making. I always have a rule that if I end up writing a long footnote, I have probably made a misjudgment, and that I've probably written something that ought to be in the text. And frequently, I give up and I'm elevated to the text. If it's so important that it takes up more than a few lines, it's probably important enough to be in the text. I think that's all the little bits and scraps that I wanted to kind of cover. Gerard?
I was going so fast that I think I sidestepped perhaps one of the most important things that I think that I think may be effective, and that's effective use of the facts. I mean, the reality is we're dealing with appellate court judges, and this is, and there's always exceptions. Sometimes you've got the issue that they've not seen before, but really they've seen it before, almost like 95% of the time. So they don't really need to be sold on what the law is. They might need a couple of reminders, but they don't really need to be sold. It's the facts, at least 95% of the time, that are going to win or lose your case. And so writing the statement of the facts, I think, is probably the most important part of brief writing. And I was a little bit horrified when I was telling one of my interns this a while back, and they said, well, that's not what we learned in legal writing. Our professors at law school were saying the facts don't matter, it's the law. And all I can hope is that maybe they just wanted to make sure they knew how to research or something. But I 100% disagree. Now, I have raised appeals that are all about the law, but those are few and far between. And for example, this is a statement of facts. You've seen this already. But this is how it begins here. And it may not seem that important, and maybe that's a fault of this brief. Maybe I should have told them why it's important right off the bat. But the facts of this case are that the dead guy is found in this witness. This is the crack addict witness case. So this crack addict's car is parked outside my client's apartment with the dead guy inside. And and she says that my client came down and killed him. Well, the police canvass this apartment and talk to this apartment. It happens in an apartment complex on a clear sunny day at 10:30 a.m. And the police canvass the place and don't find anybody who heard a single shot. And this was it was done with, like, I think a 45 or something. The firearms expert, and I suspect wrongly, but she testified that that would be louder than another gun. So all that, it's in the statement of facts, and believe me, it makes it into the argument, because that's really what goes to, like, do you think maybe she lied? Maybe she killed him and drove him there. And all those facts are in there too, about the medical examiner saying there's nothing to show that he was shot in the car as opposed to placed in the car. So the facts are critical. They really are critical. At the same time, I think it's critical to be concise. I mean, you've got a difficult job. You want to winnow it to something that when the judges read your brief, that they actually read it and aren't, eyes glazed over. So you got to be concise. You got to cut out what doesn't matter, but you got to find those nuggets, and they might be nuggets that you wouldn't think matter. I mean, 10:30 a.m. it was sunny outside. I mean, I had to sort of go back and read that again to get, like, those things matter. I mean, 10:30 a.m. in an apartment complex in DeKalb County, and it's a beautiful day. There are going to be people outside. So, those. I guess I want to make sure I stress, the facts really, really matter. And again, I love my quotes, and here's a block quote, and Mr. McFadden's right. I've heard that same criticism, eyes glaze over when they read block quotes. Despite what I'm showing you here, I don't use a lot of them, and I think you made a very good point. Underline, if there's a block quote that's good, but there's a sentence that's the gold, underline that sentence or do something so that, if their eyes are glazing over, at least they'll unglaze when they get to the point that matters. But again, sometimes they're important, and, I couldn't think of any better way to express that, this witness is, I don't remember this, I don't remember that, but I remember what hurts your client, then the way it came out of trial I thought was great, and so I used it verbatim, and that can be useful. One other thing I think makes a lot of difference, and I think I sort of glossed over this on standards of review. Court of Appeals requires you to put the standard of review in. The Supreme Court doesn't. I think standards of review, if they hurt you, you gloss over them and you ignore them. If they help you, that should be all over your brief. And unfortunately, you guys probably won't have this kind of situation, but I do a fair number of pretrial briefs, interlocutory briefs, say from a motion to suppress or something like that. And say a judge grants a motion to suppress, the standard of review is unbelievably favorable. I mean, I couldn't write a better one myself if I had free reign, really, except like you can't review this. And so I put that in. It goes in the standard of review. It goes in the argument. It gets repeated in the argument. It says, oh, and by the way, the judge could have found this not credible. I mean, you use it and you use it to death. And you state it as strongly as possible. Here's the familiar Strickland standard, but I don't rest with that because I know that it gets misapplied too much. So this is, part 2 of it is, hey, what does this really mean? You just have to show there's a decent chance the outcome would have been different. You don't have to show it actually would have been different. So use your standard of review. If you can say it strongly, say it as strongly as possible, and put it to work in the argument if you can. I mean, if the standard is a terrible standard, for example, sufficiency. I almost never raise sufficiency because the standard is terrible. I mean, when I started doing this, it seemed like the general practice among defense lawyers was to raise sufficiency in every case, just in case. And of course, the reason is if you win on sufficiency, it bars retrial. It's one of those sort of golden issues. But you never win on it. I mean, if a witness says it happened, then you lost your sufficiency challenge. You can only win with like a technicality. They forgot to establish some element. And those, believe me, I will raise. But again, that's an issue where the standard review works against you. So when you're deciding what to present, you got to look at the standard of review. When you're deciding how to present it, you gotta look at the standard of review. And when you're selling it, use the standard if at all possible.
Does anybody have questions?
Going once, going twice. Okay. Let's take you want to take a 5 or 10 minute break before we get this last block of ethics. 5, who says 5? Who says 10? Okay, the 5s have it, all right. 5 minute break and we'll start with ethics. Thank y'all for hanging in there.
Moderator than some other people have. My idea is that I ask the questions and then I sit back. So Jim, Robert, how do you think, how does one manage the care and feeding of a client in one of these cases?
Well, I touched on that, I think briefly earlier, but when I spoke of your client being locked up, having plenty of time, and being highly anxious, and over the years, I found that there are two basic ways to approach that client successfully. All of them, the problem with a client is that he's going to inundate. He tends to inundate his lawyers with issues. Because he's sitting there and he's talking to jailhouse lawyers. He's obsessing about his case. All of that's understandable. Jailhouse lawyers are essentially liberated from actually having to know the law. And unlike most of us who are often compelled to deliver bad news, they are not necessarily. As a matter of fact, they don't get cigarettes and favors if they deliver bad news. They get them if they deliver good news. And so you get some bizarre suggestions or insistences upon issues to be raised. I think that the way to deal with those is to treat at least the most prominent ones seriously, or some of them seriously. And I know it's time consuming, but I've traditionally tried to do that. I've taken one of the issues and I've explained in 3-page letters replete with citations to which the relevant cases are attached. To the letter they're attached, explaining why that issue just simply won't fly, why it's ridiculous, or why it's wrong. Excuse me. And you've got a credibility problem again because you're in competition with a jailhouse lawyer quite often, and they can disbelieve you. But I've always figured they can't really disbelieve the cases if you send them important cases and say this is what I've said about this is what the State Supreme Court has said about this, or what the U.S. Supreme Court has said about this, or what the 11th Circuit has said about this, or what the Court of Appeals has said about this. And, if you do that to just a few of the issues, they tend to be impressed by what you know and how seriously you've taken the claims, and they'll be more receptive to some sort of dealing with some of the others in a summary fashion. And I will usually culminate a letter like that saying, look, I've dealt with these issues, but nobody's paying me to give you a legal education, and I can't do it. And I've got limited resources to devote to your case, and I don't really think that you want me to spend them trying to tutor you on the law. And, you go to your physician and ask him to explain these things, and the law is no different, or it's not much different in that regard. And they once they've observed you taking their claims seriously and treating them seriously, then they're obviously far more receptive to something like that. And the fact is that if you're talking about having written them a 3-page letter, they know that you've already devoted some of those limited resources that you referred to nothing more than popping a ridiculous balloon that somebody's going to forward. And I think they tend to get the point of, that perhaps they are better served, their interests are better served by letting you do your job rather than, dealing with basically ridiculous issues that they can conjure up, or that come out from behind prison walls. And another thing that I found to be pretty effective also is to be candid with the client with relation to other things. For example, time is the lawyer's friend in these proceedings. You need time to read the transcript. You need time to digest the record. You need time to investigate. You need time to research, and you need time to write. Whereas the client suffers time in quite a different manner, and this is something that you can fruitfully explain to them that they're in a great rush to have that motion for new trial, for example, heard, whereas excuse me, the point you want to convey is that you don't want it heard before I want it heard, or before you do not want it heard before I can be prepared for it. That is not in your interest. And a lot of these things are eminently reasonable, and I think eventually, I think most clients understand it. Again, what you're at war with is their anxiety, and there's nothing in the world you can do about that. Their obsessiveness with respect to the conviction, you can't do anything about that. If you were in their shoes, you'd be obsessed with your conviction too. And then, of course, there's that competition with jailhouse lawyers who are quite free to raise their hopes and expectations, and can make them more resistant to. Can't do much about that either, except show them the law. Back.
Usually, I try to keep the defendants that I represent in appeals apprised generally of what's going on. And I do that through the milestones in the case. It's now at the Court of Appeals. Here's generally how things go. I had a guy who had a Supreme Court case in 2008. He was obviously, he wanted to know when the prison people were going to transport him to the Supreme Court so we could, present argument together. And I had to go through a long explanation about that's not how it's done at this level. But every time you get to a milestone, you're submitting your brief, or I went up for oral argument, here's what I think, and now we're just waiting. That, in my experience, that tends to keep folks satisfied. Now, you will get some who aren't satisfied no matter what you do. And they'll send you letters and say, I want you to do that. One guy told me that the judge was taking too much time considering his motion for trial, and therefore I was to dismiss it and file a notice of appeal. And I wrote back and said, fine, and then all the issues we've got are waived. And he had a venue argument, which eventually overturned his conviction, but I had to write back and say, that's a bad idea, and here's why, and kind of laid it out. And he wrote me back and said, okay, that makes sense, and he sat down and backed down. So one thing I would suggest not doing is, you're going to get letters from these folks who say, what's the status of my case, or I found this case and it says A, B, and C. I know some lawyers take those letters, throw them in the files, and don't respond to them at all. I think that's a mistake. It's like you're stoking a time bomb. Respond and say, thanks for sending me that, but this has nothing to do with your case. Do it politely and professionally, and I think that you'll be able to maintain a decent relationship with that person.
One thing that I forgot to mention, and other speakers have mentioned Jones versus Barnes, the case that makes it clear that the selection and the treatment of appellate issues is the prerogative of counsel. I must copy that case once a week, but usually when I'm in the course of the correspondence that I just described, I will send these people a copy of Jones versus Barnes, again, because Jones goes out of his way to explain why you winnow issues down, and some things that is worth the client knowing from reading the Supreme Court opinion rather than taking your word for it. And the opinion says it much better than most of us can anyway. And that once, altogether, that kind of makes it easier for you to make the calls that you have to make, for a lawyer to make the calls he has to make in those cases. And most clients, the way they approach it is, obviously they don't know the law, they've got no legal training, and if they have no detachment by which they could apply that training. And because of this, they don't know the difference between a good issue and a bad issue. Now, they wouldn't know ex post facto if it was biting in the knee, So their general philosophy is, what, just 40 issues, why not 50? And you get as many as you can, and you throw them against the wall, and they think that they have this idea of what the appellate court will do, that somebody is going to be the mass crusader on that court, and they're going to look at some issue, and they're going to order an investigation, and they're going to do all this kind of stuff. They have just no idea. Whereas, in point of fact, the quickest way to lose a case is to throw all that stuff against the wall. And because a lawyer is cursed with training and the ability to discriminate between bad issues and good issues, he or she is supposed to exercise that training and discretion and eliminate the ones that most untutored clients would want thrown against the wall. And it's just one of the things you have to deal with. But as I said, if you can demonstrate that you know what you're talking about, demonstrate your sensitivity to the position they're in, then all of those messages get conveyed a little bit better.
Let's shift gears for a moment and think about the ethical underpinnings about why we're here. It would be, we've got limited resources available for the defense of these clients. It'd be more economical if the public defenders could just represent all the co-defendants in cases. We wouldn't need conflict defenders, and maybe we wouldn't need to be imposing on all of you. Why can't we do that?
Yes, we can, as a state legislature won't let us.
Well, one of the reasons, too, is that, and I think most jurisdictions, appeals run on the record of the trial. There's relatively little opportunity to expand that record. And I think that when you've got that kind of thing, you have co-defendants, probably doesn't make a difference whether they were tried separately or tried together. But I think that a lawyer confined to the paper record is probably relatively free from any real conflict. The problem we have in Georgia is that we have this opportunity, and indeed for some matters, the obligation to expand the record through that motion for any trial. And that tends to put appellate counsel in pretty much the same dangerous position as trial counsel, where the danger is that the obligation to keep one client's secrets will be in conflict with the obligation of the other client to use those secrets in his interest. That to me is the real source of how the traditional conflict kind of endures into the appellate process. Again, my view of it would be entirely different if appeals were limited to the sort of the paper record of the conviction. I think there would be far fewer opportunities. Well, you wouldn't have the problem of secrets being divulged, because if something's not on the record, it didn't happen, you can't use it anyway. And you could argue each case sort of on its own legs. And the fact that the law is the same, is incidental, I suppose. It shouldn't affect the advocacy, I would imagine.
Switch to another ethical topic. To what extent, if any, should an appeal be structured with the idea that the appeal is not the end of the road? There's a right to pursue habeas in the state courts, and then to appeal in the federal courts. As an appellate, as a lawyer on direct appeal, are you doing anything to set up or preserve habeas rights?
I don't, personally, I think if you're the appellate lawyer, your job is to deal with what you've got, present the issues, I don't know that it's necessarily wise to be thinking ahead. I mean, it may be wise to say, I raised the issue and preserve them. But I don't view, at least from my standpoint, that the appellate advocate's role is to set up federal or state habeas. But I'd like to hear what Jim has to say, because he's done more habeas than I have.
Well, it's different. I think what Robert has expressed is probably the governing sense in ordinary cases. But death penalty cases kind of turn the world on its head. For example, everything that we've spoken of, or one of the things we've emphasized today, that idea of winnowing issues down and discriminating among them, is absolutely 180 degrees from the rule that prevails in death penalty practice. And the reasons are actually pretty clear. In an ordinary burglary case, contemplating the end of the day is you can do that. In a death penalty case, contemplating the end of the day can be terrifying, because that could result in your client being executed. And so, whereas in an ordinary appeal, you want your best issues going forward, you want to conclude the case somehow, and you hope to win it. In a death penalty case, a part of the game is a lot of those cases cannot be won, or certainly not easily won. And a great deal of the emphasis is retarding the system, is making the record more confusing, the arguments more numerous, the case more complicated. And always in the appellate phase of a death penalty case, those people do have their eyes on the habeas aspect of it. Because unlike other ordinary, Joe Blow who did a burglary, these people are going to be represented pretty much throughout that process. And the idea of saving something for the habeas lawyers is very, very prominent in capital appeals. As a matter of fact, the bane of our existence, that Garland case and this easy substitution of counsel, in death penalty cases, they try very hard, and trial lawyers understand this, to keep trial lawyers on the case, even if they're not going to do anything but sign the brief. And the reason they do that is to save Sixth Amendment claims for habeas corpus, where frankly I think they belong. But there's a case I think going on now over in Douglasville